Hi, I'm Lois Baisley Carlisle. I'm an attorney, and I'm here to give you some standard bankruptcy advice. And I will start with a standard disclaimer that no representation is made that the quality of legal services provided by me is greater than any other attorney. Well, when you go to see an attorney about filing bankruptcy, bankruptcy can be and is financial planning. You have to learn how to handle your debt and income ratio after filing bankruptcy to have a bankruptcy help you to the best that it can. So part of filing bankruptcy is to get yourself on a better budget, and to that end I'm going to do a series of videos that tell you several ways to save money and help you understand the bankruptcy law so that you can live a more comfortable lifestyle. There are several mistakes that clients often make that I'm going to talk about. Bankruptcy paperwork is very difficult. Bankruptcy is very complicated. If you use an attorney that doesn't file bankruptcies very often, that can be a mistake because they simply may not know what something means. I continually learn. I've been doing bankruptcies since the late early 90s, I guess. It's also a mistake to use a document preparation service or a secretary that worked for Joe Smith and knows how to do the paperwork. Use a seasoned attorney. Do not try to do a bankruptcy by yourself. The goal of bankruptcy is to give you a fresh start. Well, keep that in mind when you say, I don't want to list this person. I like this person. I don't want to do this to this person. I'm not going to tell my attorney about this person because they'll make me list this person, and I don't want to tell this person. I want to try to hide this car. I want to try to hide this boat. Well, you got to tell your attorney this. I was in court once, and the trustee said, "What happened to the boat?" And the lady said, well, and it wasn't my client, it was somebody else's client, but she said, oh, well, I put that in my mom's name so I could file bankruptcy. Well, you don't want to be that person. If you want to keep on using credit, you've got to pay all your bills off on time. Otherwise, if you are late on one credit card, pretty much they're going to go up across the board. If you don't owe people, you don't have to list them. So if you owe your doctor a copay of $20 and you don't want to list him, pay it off because then he's no longer a creditor. You do have to list anyone that you owe money to. You also have to list anyone that you have paid over a certain amount of money within a certain time before filing for bankruptcy. The debts you owe to people you don't disclose might actually qualify you for a better deal when you file bankruptcy and might actually help you pay those folks you want to pay quicker. There's all kinds of rules that we have to look at. One is kind of the credit card rule. Don't use your credit cards once you've decided to file bankruptcy. Charges for luxury goods and services owed to a single creditor totaling more than $500 or $600 within 90 days of filing are presumed to be non-dischargeable and may be found due and owing. They can file an AP against you, have that debt declared non-dischargeable. So if you're going to go Chapter 7, stop using your credit cards, wait 3 or 4 months to file. Cash advances totaling more than $750 for all creditors within 70 days of filing are also presumed non-dischargeable. And the same thing, the creditor can, and a lot of creditors do, file adversary proceedings against you to have the debt declared non-dischargeable. And those lawsuits don't look nice. They, a lot of times allude to fraud and say you're trying to get by with something. If you tell an attorney you've charged up a bunch of money on a credit card, they may advise you to wait a requisite period of time before filing bankruptcy and not take out any more debt. An adversarial proceeding is simply a complaint, a lawsuit filed against you alleging fraud. Now, with regard to family member, you cannot treat your family members any better than you can any other creditors with regard to paying debts. A bankruptcy trustee can reclaim any amount repaid to a family member within a year of filing bankruptcy, even though amounts under $2,000 are generally too small to bother with. There's the retirement account rule as well. Retirement accounts are generally exempt from the trustee being able to take it. In a Chapter 7, you can wipe out the debt that you have and usually keep whatever you have in a retirement free and clear. Do not drain your retirement accounts to pay down certain debt and then file bankruptcy on the rest. The trustee could set that payment aside. Property. Don't transfer property out of your name, just like the lady with the boat did, and then file bankruptcy. A trustee can undo a transfer of property that personally belonged to you if the transfer was made within 4 years of the filing of a bankruptcy and it was done with the intent to hinder, defraud, delay, hide money, assets from creditors, or simply if a fair price was not received for that asset. A second mortgage, equity line of credit, credit to pay debt rule. Don't take out a loan against your home in an effort to reduce the equity. You can often file bankruptcy and not lose this valuable asset. If you take out a second mortgage to pay credit card debt, you could be putting your house at risk, and if you can't afford to pay it without it, you may not be able to afford it with the second mortgage. Now, there's an FTA rule in criminal court. In criminal court, you get an FTA if you fail to appear. That is a failure to appear, and it comes with a price, such as a warrant, additional court fees, a free ride to jail, and free room and board for a while. Do not assume that you can avoid a lawsuit simply because you've decided to file bankruptcy. A collection case continues until your bankruptcy case is actually filed, which is only going to occur after you've met with an attorney, paid all the fees, provided the necessary information for the 40 to 50 pages of bankruptcy forms or more, you've reviewed them, signed them, and returned the forms for filing with the bankruptcy court, and you've completed the required debt counseling program. In bankruptcy court, once your case is filed, you need to appear in court at all court dates unless your attorney's office tells you not to appear at court. Your attorney will often not be able to tell you until a day or so before the court date is scheduled whether you have to go. Truth is absolutely essential to filing a bankruptcy. An attorney can only provide advice based on the information provided. Failure to notify your attorney about your assets can lead to the loss of those assets, denial of your discharge in your bankruptcy, fines, imprisonment, or all of the above. There was a young man who had called and asked one of the attorneys here for advice the other day, and the attorney had given advice based on what he told him. The kid, I found out from somebody else, had failed to give him all the advice, and then the kid called me and asked for some more advice. And he was talking about what one of the other attorneys had told him. And I said, son, the advice that you gave Terry was not complete, and the advice he gave you was faulty based on the incorrect data that you gave him. You have to give your attorney every bit of information that your attorney asks for, anything financial, anything about assets, so that you don't end up with that kind of problem. Tax refund rule: if you file for bankruptcy during tax season, the bankruptcy trustee may take some or all of your tax refund to pay your creditors. And in a 13, sometimes you have to give the tax refunds up every year to the trustee to pay your bills. Well, okay, how are you going to keep from getting back in this shape again? Budgeting is everything. And the next recorded session I do on this will be on all kinds of choices that will help you with your budgeting needs. Thank you, and take care. Again, this is Lois Beasley Carlisle with tips, financial tips to help you whether or not you file bankruptcy. Bye-bye.